Hello and welcome to the David Carrier Show. I'm David Carrier, your family's personal attorney. Now's the time to give us a call, 616-774-2424. That's 616-774-2424. We'll get your question, comment, or concern on the air. That is, if it has to do with estate planning, elder law, real estate, or business law. You can also drop us an email, david@davidcarrierlaw.com, or you can go to the website. You can always go to the website, davidcarrierlaw.com. Lots of good stuff on the website, and you can leave us a message there as well. And we're on Facebook and those things as well. So give us a call if you're wondering about wills, trusts, or probate. That's that estate planning part of things. Elder law has to do with, it's not just if you're elderly, actually, because we've got people in their 50s too, but if you're wondering how to beat the high cost of long-term care, if you're wondering about asset protection, you want to make sure that what you've built up over your lifetime lasts as long as you do. The tragedy, of course, is that it does not in many, 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 many cases. Does not last as long as people do. They go broke. We call it nursing home poverty. And if you do your estate plan correctly, this is my view of the world, okay? It's been that way for about 30 years now. If you do your estate plan correctly, properly, the way the good Lord intended, maybe I should make that claim. But anyway, if you do it correctly, the first thing that we're protecting is you, right? Single or married, protecting you, protecting your spouse, making sure that what you've built up over your lifetime is there for you. That's the point. Because if you're listening to the show at this hour of the day, right, you're the people who work and pay and do all the good things. And the fact of the matter is that most of you will go broke in long-term care. And that could be at-home care, it could be assisted living, could be skilled nursing, could be any, this is what the government says anyway. That's from the National Institutes of Health, long-term care.gov. You can look it up yourself. You don't have to believe me. What do they say? The answer is out there in the interwebs. The government has provided. So, just check it out. It's not Dave Carrier saying this stuff. It's the way it really is. Now, I've seen it a lot, that's for sure. But if you do your planning correctly, you're okay. Kids are okay. Everybody's okay. You don't do your planning. And look, if you didn't plan ahead, if you're one of those people who lived on a credit card, it happens, payday lender and all the rest of that stuff. Well, you can't magically make that stuff up. It has to be founded based on your working and you're doing the good things. All the rest of it. That's what estate planning is based on. If there's nothing to save, there's nothing to save. There's not much we can do to help out. But if you have been paying on the mortgage, if you've been building up your assets, paying into the 401k, all that sort of thing, well, then we can, do our best job. I guess that's the point. We also deal with real estate. So if you're looking to buy or sell a home, if you're thinking maybe I should buy on land contract or something like that, then give us a call, 616-774-2424. Of course, business law, that's one of those things near and dear to our heart. If you decided, managed to survive, let's say you managed to survive the pandemic, or you wanted to start your own business and you actually did it, there's a lot of headwinds out there and they're getting worse all the time. Give us a call. We can help out. We can help out with any issues you've got there. One of the things I did want to touch base on this morning, you've heard me talk about deeds and planning deeds and all the rest of this stuff. And we got another email about this. And I just wanted to cover it again because it's one of those things that I tell you what, it puzzles the paralegals, even the folks in the Medicaid department at the office. Tell us about life estates. Okay, fine. So here's how a life estate works. Here's how real estate works. Okay. Let's say you buy a house, right? And you have a deed and it's a warranty deed or a quick claim deed, doesn't matter. But it says, this person on the one side Joe Blow gives to Sally Sue the land, conveys and grants to. Right? In other words, it's an absolute grant. You get everything. Well, what are you getting when you buy land? Okay, it depends, right? I mean, if you go out and buy a farm, go out and buy some acreage out there somewhere, and you own it, and there's no zoning, like in Texas, there's no zoning. Okay, so you can pretty much do what you want with the land. Now, you can also buy in a subdivision with all kinds of rules. Those of you who know what homeowners associations are like, or a condo association, you know that when you buy land or you buy a condo, right, you're buying a very specific group of rights with regard to that land. You're not getting it. You can't just put a bonfire in the middle of it and dance around it. You can't do that. When you buy in a site condominium, in a condominium, okay, you can't do that. In homeowners association, you can't do that, right? There are various rights that you have. Sometimes you can buy land and you think, well, I can put a house on it. Well, maybe you can and maybe you can't. Depends on the zoning, right? Depends on the lot size. So when you buy land, it's not like you get everything with it. You get some stuff. You can use it like this. You can use it like that. Okay. Now, there's another thing that you usually get when you buy land, and that is the ability to sell it to somebody else. So when you're done using it, you can sell it to somebody else, usually. And you have the right to use it yourself to some extent. So here's the idea. You buy land, right? Real estate. You buy a house in a subdivision, what have you. You have the right today to live in that house because that's what you bought, typically, right? So you have the right to use it today, and you have the right to sell it to someone else in the future. Okay. So you can live in it as long as you want, and you can sell it. Now, living in it today is what we call the life estate. Okay. You can live in it till you die, because then you're dead and you're not living anymore. Okay, fine. But then you have the right to give it to somebody else. That's called the remainderman, the remainder man. Ooh, sexism. Anyway, so you've got the life estate and the remainderman. Usually, those are the same person. You buy a house, you have the right to live in it now and to give the remainder, when you're done with it, to someone else, to sell it to somebody else. Okay? Unfortunately, what a lot of folks do is they give the remainder interest to their kids. So they say, I'm going to give you the cottage, but I have the right to live in it for the rest of my life. So mom gives to daughter, right, the cottage, reserving a life estate. In other words, mom can live there as long as she wants, right? And when she dies, that life estate is released, and now the daughter can live in the house. In the meantime, when mom gives daughter the cottage, reserving a life estate, that means that daughter can't move in. She can't do anything until mom dies. And when mom dies, then it's daughter's property. Okay? So that's the idea behind the life estate and the remainder interest, remainderment. So mom is what we call the life tenant, because mom's living there during her lifetime. And then daughter gets the remainder when mom dies. And the problem is, and for many, many years, people would deed the cottage or the house or the farm or the whatever, commercial building, to the kids, keeping a life estate for themselves, which seemed to make sense because, well, while I'm alive, it's mine. And then when I'm gone, I don't care anyway. You can have it. That was the rationale. Of course, you're not dead yet. You might want to do something else with the property. You might want to sell that remainder interest. But that's not what people would do, because they couldn't anymore, because they deeded that remainder interest to the kids. So here's the idea. Life estate while you're alive, remainder interest after you're gone. We got an email that shows just how bad an idea this is. Coming up next, you're listening to The David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to The David Carrier Show. I'm David Carrier, your family's personal attorney. I promised you last, give us a call, 616-774-2424. If you'd like to get your question, comment, or concern on the air. See how easy that is, 616-774-2424. And don't complain, it's not an 800 number like we used to have, because every number is like an 800 number now, isn't it? I mean, doesn't everybody get unlimited calling? I think you do. So anyway, there's no point in keeping, we still have the 800 number, the 888 number, but don't use it very much. Anyway, I promised you an email in the last segment, so here it is. At this time, she is not on Medicaid. We purchased from my parents in 1992 with the life estate at half the selling price. My father passed in 2004, and my 97-year-old mother is in a nursing home rehab for fractured hip. Not unusual. And recommended to stay in nursing home rest of her life. Again, not unusual. Will my remainder man value, we even knew about that, right? Will my remainder value go down and her value go to paying nursing home? ? Well, here's the thing. You did it more than 5 years ago. So they can't go back and say that there was a divestment. There was a divestment. In 1992. Okay. So 30 years ago, there was a divestment. Well, back then, the divestment period was only, 2 years, 24 months. And then it went to 30 months, and then 30 months or 60 months if it was done in a trial. There was a thing back then. But anyway, point being, it's 5 years now for everybody, and 31 years is more than 5 years ago. So you don't have to worry about them coming back and saying, oh, mom and dad sold a house for cheap. Plus, mom gets to keep the life estate even though she's on Medicaid. All right. She gets to keep it. In other words, they won't make her sell it. And if Michigan ever joins the 86% of states that do the Medicaid liens, which I think Michigan will, as a matter of fact, just a matter of do the math, right? I'll explain what I mean by that later. But anyway, right now, Michigan does not put a lien on your property, doesn't force you to sell your house. Other states might, other states do, but not Michigan, not yet. Plus, even if they did put liens on, the fact that it's a life estate means that when mom dies, the life estate goes away. All right, there's nothing for the lien to attach to because it only lasts as long as mom does. Now, the ability to live in a property for a certain number of years does have a value. So it says, will my remainderment value go down and her value go to paying the nursing home? There's a value, back when mom was in her 60s, there was 30 years ago, she's 97 years old now. So when she was 66, 67, that's when they did this life estate thing. Well, mom at age 67 had the right to stay in the house. And back then, back when mom was 67, the right to stay in the house was worth about half of the value of the house. How do we know this? Well, because the state of Michigan very thoughtfully publishes a table called the Life Estate Factor Table. And the Life Estate Factor Table tells you how much a life estate is worth. We used to have to do expert witnesses. I'm talking 25, 30 years ago. We used to have to do expert witnesses and stuff to testify as to the value of the life estate, present value, and all that. It's all done for you now. It's all in a table. State made it very easy to figure out what a life estate is worth. Okay? So for these folks, it's no problem. It looks like they've been living in the house right along for the last 30 years. So they're not going to move, and then the house isn't going to be empty, I'm guessing. Maybe I'm reading too much into it. Maybe this was just mom's house. So until mom dies, the kids, the remaindermen, are going to have to pay the taxes and the utilities and everything else, because all of mom's income is going to go to the nursing home. And then Medicaid will pay the difference, but they won't come after the house. Why? Because when mom dies, the house belongs to the kids. They already own the remainder interest. When mom dies, now they have the right to live in the house today. They have the life estate. So let's recap. Two basic rights that you have when you buy real estate. One is the right to use it today. That's the life estate. While you're alive, you have the right to use the property. You also have the right to sell the property into the future. Okay? That's what we call the remainder interest. The reason that life estates, the way people used to do them, were so bad was that when this situation occurred, frequently mom would sign the life estate to the kids. Not 30 years ago, but right now, today. And that would disqualify mom from receiving Medicaid. We give her a penalty period, is really what happens. Okay. Mom is penalized so that the kids can live in the house or sell it or do whatever else they wanted, because that life estate, that right to remain in the house, had value. And if you sell that value or you give it away, now you've got a Medicaid problem. The ladybird deed. Now, okay, are we all together on that? I know this is difficult stuff. Works better when you have a whiteboard and you can explain it all. Just grant me that one. But anyway, here's the other thing. The ladybird deed that you've heard so much about, right? Ladybird deed. That solves this problem by giving mom not only the life estate, but the ability to do whatever else she wants with the property. The problem with the ladybird deed is that when mom dies, then the house goes to the kids, right? But in the meantime, if she needs long-term care, and this is true in almost every other state, then the state can put a lien on the property, even though they have the ladybird deed. You see, this is the unspoken failing of the ladybird deed, of the transfer on death deed. Okay. And that is that it doesn't start any clocks. It doesn't protect anything for the kids. It protects mom. Yes, it does, because mom still owns the property. But that's the problem. Mom still owns the property, which means that someone can come and take the property away, even though you have the ladybird deed. So it's 6 of one, half dozen of the other. Pick your poison. Which one do you want? Do you want the ladybird deed, right, where you can't sell it till after mom dies? Or do you want to do a typical life estate deed where mom can't control the property, right? But when you die, then you get it. But you have to wait until mom dies. In both cases, you have to wait till mom dies. But with the ladybird deed, you don't get anything in the meantime. With the traditional quit claim, reserve a life estate deed, you get the remainder interest now, so that you know that eventually you will get the property. You don't have that with the ladybird deed. And the sad fact is that people count on the ladybird deed like it was a magic cure, and it really is not. Give us a call, why don't you? 616-774-2424. I'm David Carrier, your family's personal attorney.
Your show.
Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. Now's the time to give us a call, 616-774-2424. That's 616-774-2424. We'll get your question, comment, or concern on the air. That's if it has to do with estate planning, elder law, real estate, or business law. We've got Todd on the line. Hello, Todd. Welcome to the David Carrier Show.
Morning.
Morning.
So back in the winter, your firm helped us with the filing of a ERTC credit.
Mm-hmm.
And just curious, we finally are getting checks from it. How does that affect? Do we just claim that as income this year, or do we have to go back and redo every 2020, 2021 tax returns? How does that work?
So there are two theories on this. So let's kind of recap.
Theories.
Well, you're dealing with the IRS. What do you want?
Right.
Yeah.
That's why I can't get a good answer.
It's only when we want to pillory a certain ex-president, do vague notions of law become, oh, this is the way it always is. You know what I mean? And with the ERTC, it's no
Right.
different. With tax law, it's no different. When I was when I was on active duty and getting my tax degree from Georgetown, there was a buddy of mine, a guy who had been active in taxes for years. I was a new captain, but anyway, he used to refer to his 1040 as his opening bid. Think about that, right? And
Right.
and every year when people, tax time runs around, there's some institute that, or one of the money magazines, I think, and they have the same exact client file to give it to 4 different preparers from, one of the mass preparers like H&R Block or one of them, all the way up to the most expensive silk stocking CPA firm. And they all come back with different results. So when you're looking at taxes, you got to accept that a lot of it is theory, a lot of it is advocacy, a lot of it is how well you prepare for this stuff. No, ERTC is no different. And so many people leave so much on the table because they don't qualify under the numbers theory. All right, there's the numbers, where's your where your gross receipts down a certain amount, or did you have to change your line of business? Those are 2 different tests. The CPAs are very comfortable with the numbers test, you would expect them to be, and the lawyers are very comfortable with the facts and circumstances, governmental order related to suspension of trade or business test. Right now, we've got about a dozen attorneys, maybe 14 attorneys in my office who are doing the ERTC work, these tax returns and what have you. And most of the clients we're serving, they say, well, we don't qualify on the numbers. And so our CPA, and this is the thing you hear over and over and over again, CPA says you don't qualify. Well, you do qualify, just not under the numbers test, under the other test. So let me get to your question, which is, what do I do once I get the money? Okay. And we have a program for this too. Right. You won't be surprised. So there's 2 ways to do it. The first is, as you stated, to go back and reopen those previous tax returns. And if you took the money itself is not taxable, but you may have taken deductions relating to the money. And then what you have to do is you have to include that back in income back in the day. Okay. So that's where you get into I got to go back, amend my corporate tax returns, amend my personal tax returns. So that's there's no question that works. There's no theory about that one. If you do that, it definitely works. I've talked to 2 CPAs now. One's a fairly large regional firm, and their position is that, and other people tell me they're crazy. Okay, don't get me wrong. So I'm not giving this as advice. I'm repeating. This is just what I heard. What they say is, this one firm says, is that you can take it into income currently. That there's a way under the regs, there's a way to do it so that rather than go back and amend the returns, you can claim it as income in the year received, if you're a cash basis taxpayer. So, it's one of those things.
So the total amount or the amount that you deducted before?
Yeah, the amount that relates to the prior deduction. And I'll tell you, one of the things that really cheeses the IRS about a lot of these, there's a lot of fly-by-nighters doing the ERTC. It's just, it's terrible, but I mean, that's the world you got to live in, where they don't get the governmental orders. They don't do a tight relationship of the orders to the suspension and on and on. And it's done poorly an awful lot of the time. But we've got thousands of orders in the database. So, we're pretty meticulous about it. It's the same way with the amending the tax returns. So we put that in writing. We tell you about it over and over again. We even have a program now where the clients for whom we got the tax credit, we're giving, get it done by your own CPA. God bless you. Right? That's fine. But if you want, we can do it. We can do that as well for an additional fee. I won't kid you. I mean,
So I should probably get a hold of your firm then next week or so to set something up. So,
Todd, if you do that, that would be great because, and I'll put you in touch. One of the things we'll do is put you in touch. We'll give you the option because it is an option. I saw enough of, I followed the explanation closely enough to think, there might be something here, and it's a major CPA firm and they're doing it. So, you decide. But obviously for some
where you talk to the average accountant and they don't have a clue.
Well, ain't that the case with the ERTC? Yeah, it's the same thing with the ERTC.
Yeah.
In fact, I was at a convention of CPAs a couple of weeks ago, and it was one of the people who refers us cases invited me down there, and I'm talking to these guys, and you would think that by now people understood what was going on with the ERTC. The CPAs don't get it. We did a speak, did the dog and pony show and all that, and just in conversation with these guys over a couple of days, it was it's you don't want to be unfair. I mean, they've got a lot of other things going on, but at the same time, you would expect that, and these guys were, business advisors, small practice advisors, medical practice advisors, hospital advisors. You would think that they would know exactly how this thing worked. Not the case. Not the case. So it's one of those things where you would think that the people that you would normally go to for something like this, where you think they would understand it and be able to guide you through it, the answer is you can't do it. Most of our clients have asked their CPA about it, and the CPA told them they couldn't do it. And then when you dig into it, it's like, I've got 3 governmental orders. I've got 6 quarters here where you were affected. That he documented like this, and it's just that they ignore the fact that they ignore the suspension test, which is where most people qualify. But it's there. It's in the law. And the IRS is accepting it. So there you go.
Well, they accepted it and sent us some checks. So I will get a hold of you guys next week and get the ball rolling on what to do with it.
Okay, Todd. Thanks very much.
All right. Appreciate your help in the front part of this and on the back end. Thank you.
Thank you. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier. I'm sorry, that's one of my favorite songs. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. We've got Doug on the line. Hello, Doug. How can we help?
Hi. How are you?
Good. What's up this morning?
Yep. My wife and I are current clients of yours.
Oh.
And we have, my wife owns a family farm.
Right.
And long ago, there was a parcel that was deeded off, and the neighbors now have a house on it. And then later down the line, they gave a parcel to one of the sons, and somehow they forgot about the first parcel, and what they gave to the son overlapped significantly from the existing exception parcel. So this has caused a whole bunch of conflict in the family. But to reconcile that, would we have to re-describe the parcel that they gave him and take out the encroachment?
Yes.
Yeah.
So let me see if I understand. Back in the day, we gave Timmy. Now, are these all family members, or do we sell off part of this to a third party?
Yeah, the first sale of the parcel was a third party, and so
Okay.
that's the neighbors down the way.
But then they reconveyed part of the another parcel to one of the kids, but this time
Yep.
they included part of the land they'd already sold off.
Yeah, it was a big encroachment. Yes.
So where's the conflict? I mean, how you can't reconvey property that you don't own? So
Correct. So yeah, going forward, we're going to get some things reconciled on that farm in the next several years. So part of that's probably going to have to re-describe the parcel that went to the son, and go
no,
forward
quite.
from
There's
that.
no, Doug. There's absolutely no question about that. You can't convey.
Yeah.
You know, the I hope the family member is not in conflict with the third party. Are they? I mean, nothing to fight about, really?
Not.
No, there's nothing to fight
Right.
about, really, because the well, was it just a kind of a whoopsie? Is that what happened? I mean,
It appears to be. Yeah, this was all done when Mom and Dad were still alive, and so now they've passed, and my wife now owns the farm, and nobody's been sure, and they haven't wanted to dip their toes in the water of getting this reconciled. But I figured this is what would probably have to shake out.
oh, you got to get it done, and you got to get it done soon, because here's the next step, right? Because Mom and Dad are gone. They're the ones who actually made the mistake, right? And we've got
Yep.
family members right now who understand what's going on. But what happens when it gets to the next generation? And now I've got grandkids, right? Who all they know is our dad was given X amount of land. We got a deed that says we own it, but they already sold it off to somebody else. And now they sue your wife, I guess, who still owns the farm, right? She owns the big part of the farm.
Yeah.
So maybe
Yeah,
they
she
sue
does.
her, saying that this was a fraud on their father, or something on their relative, their parent, was a fraud on the father to give him this land. I mean, now's the time to get it done when everybody still remembers what the hell was going on. Get the deed
Yeah.
corrected. You absolutely have to have somebody out there and survey the thing or whatever. At least do I would say a survey, but at least a surveyor who's got the equipment to do the meets and bounds description. You know what I mean? That's got to get got to get clarified, because you're just asking for trouble down the road. I mean,
Yeah.
so you're saying the next several years? I'm thinking the next several weeks. Let's get this thing done.
Well, yeah. Yeah, I'm sure you're right. We gotta get this corrected here real soon. So
yeah,
okay, this was the answer that I thought I would hear, but wanted to check in.
Yeah, absolutely, and thanks for calling. I guess it's easier to get hold of me on the show than at the office, isn't it?
Real good. Yes. Thanks, David.
Thank you, Doug. Take care. Okay, we've also got it says cars. I'm thinking it means Carl, maybe, on the line.
Hi, it's Kara.
Oh, Kara. Okay. I see. He was going for the A and he hit the S. There we are.
So I have a will and estate. I've had one for several years, always tweaking it. I have a terminal illness, so I'm always just kind of, making sure everything is ready.
Yeah.
And right now I am updating the beneficiary distribution on my 401k. And one question I just would love to confirm.
Sure.
When that's dispersed, my children, my adult sons who are heirs with my husband, will they need to pay tax on that or not?
So here's the way it works. The part that goes to your husband is rolled over to him. Okay. So he's treated as if it was his IRA from the get-go. in terms of when he has to
Okay.
take distributions. So it's 72 right now. He doesn't have to start taking distributions till 72. With your kids, however, and for him, it's still an IRA, which means that it cannot be sued away from him. It's his. They can't take it away from him. Okay? That's with regard to your husband.
Okay.
Very different when we get to the kids, because the kids have to deed it out. The kids have to take it out within 10 years. And the regulations, which they're not enforcing this year, but probably will, the regulations say you have to take out required minimum distributions based on your life expectancy. This is for the kids. They have to take out the required minimum distributions, but 100% has to be distributed in 10 years. Okay? So
Yeah.
that's the idea with regard to the kids. So if half of it is going to hubby, then hubby, he has to start taking out when he's 72. The kids have to start taking it out pretty much immediately, within a year of your death. And then they have to take it out over the 10 years and lump sum at the end. So they have to have it 100% distributed in 10 years. That's under the Secure Act. But there's a much better thing that you could do with it, which I'll get back to after the news, because I'm getting the high sign. We've only got a couple of minutes. Can I ask,
Okay.
what is the nature of the terminal? I mean, we all have life. I mean, that's a terminal illness right there. But is this an acute thing or?
Oh, yeah. I mean, I metastatic breast cancer that I've had for 5 years. So,
Got it.
It's progressing. And I mean, yeah.
Okay. Yeah. Well, just, I got the metastatic medullary thyroid cancer. So there you go. Stick around till after.
I'm one of those, like, hope for the best, but you also need to just be prepared. And that's
Absolutely.
what I'm trying to do. I think it's the ultimate gift of love for your heirs to take that, have that all set up for them.
So true. So, all right. So stick around, because in the next segment, we'll tell you how to put a bow on that present to the kids and your spouse.
Oh, thank you so much.
Yeah, no problem. All right. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Hello and welcome to the David Carrier Show. I'm David Carrier, your family's personal attorney, and you have found the place where we talk about estate planning, elder law, real estate, and business law. So if you have a question, comment, or concern about wills, trusts, or probate, how do we beat the high cost of long-term care? If you have a real estate or business question, now's the time to give us a shout, 616-774-2424. That's 616-774-2424, and we'll get your question, comment, or concern on the air. We're talking to Kara right now, and I hope she's still with us. Yes?
I am.
All righty. So here's the thing. Kara, unfortunately, has a terminal diagnosis, and she wants to make sure that her assets go to her husband and kids appropriately. Among other things, she has a 401k, and it's going to be split. And check me if I'm wrong on this one, Kara. It's going to be split between your husband and your kids. Is that right?
That's correct. My husband is not the biological father of the children. Just for context.
Yeah, I gotcha. Okay. So here's the thing. The portion that goes to your husband, your spouse, all right, so it's husband, wife, spouse. That portion is going to be continue as an IRA. In other words, a retirement plan account, retirement plan assets. What that means is that if the husband gets sued, they can't take the IRA away from him. That's protected. Also, he doesn't have to start taking required minimum distributions from the IRA until he's 72. And depending on his age now, it may be as high as 75, because it's cranked in there to the minimum age where you have to start taking the required distributions is going up. It's going up to 75. So that's for him. The problem comes with, and that's an issue too, and I'll talk about that in just a minute. But the bigger problem is with the kids, because the kids have to take required minimum distributions for the first 10 years and then a lump sum distribution. Then they have to balloon it. That you can't change that. But here's the difference. When the kids get the account, it's just a checking account. Okay, it's just another asset. And I'm guessing is this a traditional IRA or a Roth?
I have one Roth and one traditional. And the total approximate value for each of them as of like today, right?
Oh. Mm-hmm.
Who knows? It's about 200,000.
Okay.
So it's a significant amount. They're one is like, they're under 30. They're in
Right.
26 to 30. Mm-hmm.
Right. Okay. So good. So here's the problem with the traditional IRA and with the Roth too, because like I say, for your husband, he can get sued all day long. They can't take his IRA, even the rollover IRA. Same for you. But for the kids, it's just another checking account. So if there's a divorce, a bankruptcy, a lawsuit, student loan debt, cell phone they forgot about, whatever, now the creditor can come in and take the IRA money. That's one problem. But the worst problem is not that they lost the money. The problem is, and this is with the traditional, not the Roth, the traditional IRA, they're going to still owe the income tax on the money, and they don't have the money yet. Okay? So what we do, and we do this for the spouse as well, we do an IRA trust, an IRA beneficiary trust. Now, the advantage for your kids is that, number one, no one can take the IRA away from them now because it's protected by the trust. So you don't wind up in a situation where divorce, bankruptcy, business failure, whatever, now, instead of getting $50,000 tax deferred, instead of that, the kids get nothing but a tax bill for the $50,000. Do you see? Because IRS doesn't care if your kids got the money. If their creditors got the money, as far as IRS is concerned, that's the same as if the kids got the money and paid the creditors. And so now, you've left your kids in tax debt instead of actually giving them something. The trust protects from that. So that's number one. Number two, to most people who are saving money, working and putting the money in the 401k, the IRA, that is special money. That is I worked my butt off for this money. That is, I took overtime, I didn't take vacation, and I put it into this IRA 401k. That's it's Alibaba's cave. It's Long John Silver's chest of doubloons buried on the desert island. It's that secure money. But to your kids, it's a piñata. And they're going to whack that piñata just as soon as they can. Okay? And then now, with the trust, what you can do is you can say, oh, no. You can take your RMDs for the next 10 years, but in the meantime, that money's going to grow. And then you have to take it at the end of the 10 years, okay? But by then, it's 3 or 4 times as much because they put in the Standard & Poor's 500 or some other fairly conservative, broad-based stock index fund. And now they've got a multiple of what you left them. Plus, at age 30, is that really a good time to get a sudden $100,000 influx? Maybe. I don't think so. You say, because I get a lot of people, they're going to buy a house. Yeah, well, they're going to buy a house anyway. This money is special mama money that mom put the golden nest egg, right? When you're 45, when you're 50, all right, then you can have it. In the meantime, you can still invest it however you want. This is for the kids after you've passed. You invest it however they want, and if they have an emergency, a real emergency, they can get at the money. But in the meantime, it's the gift that keeps on giving. Well, it's the gift that keeps on growing.
That's what I'd like. Yeah.
Well, that's what the trust is for. And you can't do it. Now, here's the thing. If you talk to a financial advisor, say, hey, I talked to some guy on the radio. He said, put my IRA in a trust. Their hair will fly out of their head, right? I mean, they'll freak out because if you use the just the typical trust, the revocable trust that most people do, if you use that as the beneficiary, it's going to cause immediate lump sum distribution. It won't work. You have to get an IRA trust, a trust that's designed and intended to be an IRA beneficiary. And when you do that, you're good to go. Now, here's the thing with your husband. By doing this kind of IRA trust for your husband as well, then if he needs the long-term care later on, because he's holding off on taking this money till he's 75 or whatever, now that can be protected from long-term care as well. So this money, if you leverage it right, if you work it right, this 200,000, 400,000 nest egg can really make a huge difference in the lives of your loved ones, even after you've passed. You see? But it's there for you. We do that planning for you first, but then it's still there for them. And there's just a lot more going on than putting beneficiaries on the IRAs. I mean, that's important.
Yeah.
But if you come to
especially since I have different investment vehicles, there are all those little nuances of each one.
Yeah.
And I'm just trying to, make the best decision as terms of how to set that up with, because our will and estate, everything is to a trust, but it only kicks in at, when my husband dies, So in the meantime, I wanted to do the 401k and the IRA separately as a beneficiary so they would have access to that sooner than later because we're both about 60.
Got it. What I would suggest, and this is what we do with these trusts, these IRA trusts, is you tailor them. You know what I mean? It's not a one size fits all kind of situation. And so you can limit or not limit or limit to some extent the access that the kids have to the IRA money. But what you really want to do, and this is what I think most important thing, is what you want to do is you want to prevent creditors, the kids' creditors, from taking the IRA, because that traditional, especially because that leaves the kids with a tax bill and no money. So just something to think about.
Got it.
Okay.
All right. Well, thank you, David.
Sure. And it's the kind of thing where if you just want to come in and talk it through, we don't charge for that. Just come on in and, decide what, we'll take a look at whatever you've got and, it doesn't cost. So, just a way of doing those things.
Appreciate that. I appreciate that. Okay.
Thanks, Kara. You betcha.
Bye.
Have a good day.
Yep.
You bet. Bye-bye.
You too. Bye.
You're listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. Now's the time to give us a call, 616-774-2424. You can also drop me an email, david@davidcarrierlaw.com. David@davidcarrierlaw. See how easy that is? Gosh, just amazing. Anyway, you can also go to the website, which, no surprise, davidcarrierlaw.com. And we've got all the workshops set up there, and we're expanding those. We're over now in Grand Haven. Got a nice welcome over there. Down in South Haven too, I believe, and going eastwards as well. Also, thanks to everybody who came out in Muskegon. And it's just I think I've mentioned this already. We've kind of shifted our model of how we provide services. I mean, the old-fashioned way is still there. Traditional way is still there, which is a one-on-one process, soup to nuts. Okay. But what we discovered, I say discovered, it's like, well, it's been an obvious truth for years. And the problem is that delivering this kind of thing, the kind of work that we do on a one-on-one basis, is extremely difficult. I mean, we've keeping the paralegals and finding new ones and all the rest, especially nowadays where you've got such a demand for talent, and it takes good people to keep the promises that we make. Some pretty big promises around here: asset protection, long-term care protection. Your trust is actually going to work instead of giving you a binder full of papers that sits and collects dust until you need it, and then doesn't work at that point, which is sadly all too typical of estate planning the way it's done. It's just reality. I mean, you can ask anybody, ask a banker, ask an insurance agent, ask an accountant. They all admit that the trusts are not funded, which means that they will not avoid probate, which means that they don't work. So, point being, there's the way we've done it, and we're not backing off of that. Let me make very clear, we're not backing off at all on what's delivered, just the way we're doing it. The new way is, and this is a choice, right? That's not, you don't have to, it's not, we're not limiting everything to this model, but it cuts the cost by about half. And because what we're doing is we're saying, okay, we're having a group meeting, the way it used to be, group meeting, come to a workshop, or just come on in, right? Either way. And then one-on-one throughout. Now what we're doing is we're doing the one-on-one part when we have to do one-on-one to maintain confidentiality, to know exactly what your plan is, the very specific parts of it, okay, that are specific and unique to you. That stays one-on-one, that stays private, as confidential as it always has. But what's different is for the information meetings, right, for the signing meetings, for the funding meetings, right, those are in group. So it cuts the cost in half. It's 50% off. Sometimes for some people, it's 2/3 off, 2/3 less than the traditional one-on-one at every step along the way. And it's been very gratifying, frankly. I mean, the number of folks who are taking advantage of it is it's ramping up there, and it's been like I say, it's been very gratifying to see how, if you give people, the more that we make it possible for you to do it, the more people are doing it, really taking an interest in what it is they're leaving behind, and in getting that long-term care protection up front, which has always been our focus, right? Is making sure that your stuff lasts as long as you do. And the problem was, an awful lot of people viewed it as unaffordable. Well, it's less than 1 month of long-term care, quite a bit less, but still, it's a big number. If you're not confronting the situation right now, then, it's easy to put it off. Well, we've cut the cost, so now it's much, at least our experience has been, it's a lot more difficult for people to put it off when we've lowered the cost by that much. The other thing is the way that people do plan their estates. There are so many things that can be done. Kira obviously looking out for her spouse, for her kids. There's she has the kids and then married a different person who's not the father, not the parent. And we've got so many of those situations now where, and some people say, oh, divided loyalty. It's not divided loyalty. You divide love, you just have more love. That's what it is. Okay. So you have more concern for more people. That's not a bad thing. That's not, if it's done correctly. If it's done correctly, it's not a division. It's an addition. I know it's not, maybe that's the new math. But the point is that if it's planned correctly, right? Number one, your assets serve you. And number two, then they serve the ones you leave behind. They serve your family. And that's why you did it anyway. That's why you did it in the first place. That's why you did the work, you did the savings, all the rest of this. And the thing is, there's just so many more things you can do than people consider. And this is the IRAs are one of them. I've been on you've heard me on my IRA hobby horse before, but the fact of the matter is, with the Secure Act first, and then there were some things about the Secure Act that got cleared up by Secure Act number 2, that have to do with the IRAs. It's just very, they didn't make inherited IRAs protected assets. They didn't do that. So the consequence is that for the kids, those assets are still at risk. But for the surviving spouse, right? Again, now we can do a trust, and this was true with Secure Act. Well, it was arguably true with Secure Act 1, and now it's confirmed. that you can do a trust where your surviving spouse gets all the benefits, right, of doing a rollover. But in the trust, you can make sure that your ultimate beneficiaries would be your kids. If that's, if there are leftovers and that's where you want it to go, then you can make sure that that happens. Okay. And especially when we've got the families that are coming together and we got kids over here and kids over there and different interests, right? It is a way to be more confident that the way you want things to go will be the way. So you want to take care of your spouse. Absolutely. Take care of your spouse. But you want to make sure that at the spouse's death, when the spouse has been taken care of, when their needs have been met, right? Then you want it to go to whatever leftovers there are. Well, I'd like that to go to my kids instead of pick your charity. So, or some other kids or whatever. You have that degree of control now if you choose to exercise it. And especially when we have someone who's as thoughtful as Kara, who has been thinking about this stuff, who has been making the plans, that's just great. The thing now is to use all of the tools that are available, right? So that if you yourself need long-term care, well, how am I going to protect the IRAs now? Here's how. Well, how am I going to do this? You can do all that stuff. The thing is, when you plan ahead, then it can really work out, especially when you know what the tools are. And there are some very beneficial tools that are available that most people still don't take advantage of. You're listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Sorry, I just like this music. Well, anyway, I guess we got to do the show. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. Yes, I have absolutely no musical talent, but I do imagine myself as one of the Ventures, or if I don't know, or we could be, one of the what was it, Muscle Shoals, the backup band that did all that. Anyway, just amazing stuff. And I like the Beach Boys and Jan and Dean as much as anybody else, but this week, obviously, we've been going with the instrumentals and we got a little bit of Beach Boys, but Ventures, you gotta love them and the rest of those guys. Anyway, so here's I got some emails. If you want to give us a call, that'd be great. 616-774-2424, 616-774-2424. Or go to the website, davidcarrierlaw.com. So here's the one of these things where you can see a couple of strands of what do you want to say, myth and fiction kind of woven into this one. All right. The question is, can a grown child give themselves proceeds from the sale of a parent's home while the parent is on Medicaid in a nursing home? The house is modest, so likely be sold for less than six figures. Adult child understands. Patient will have to go off Medicaid till the sale proceeds are spent down. Okay, so why would you spend them down? Well, you wouldn't. Except that, here we go. But before the sale proceeds start being spent on the parent, the adult child intends to reimburse themselves for everything they've ever spent on the parent. That doesn't work. Are you kidding me? That's divestment with a capital D, IVESTMENT, right? Dynamite. Anyway, it's divestment with a capital D. That doesn't work. This would consume a great amount of proceeds from the sale. Yeah, no kidding. And if it sells for less than six figures is $100,000, right? You know what costs in a nursing home these days? 12 to 15. It's probably more now. It's been a while since I checked. But, the cost of long-term care is skyrocketing. Holy cow. Because you can't find anybody to work. Or you can't find enough people. And so the, supply demand, it's very, very basic. This is why it costs so much. And now the kid, so let's say you get 100,000 and the kid reimburses himself for 50,000. So how many months do you have now to pay the nursing home? The answer is 3 months. 3 times, right? Say it's 15,000. 3 times 15 is 45. Maybe 4 months at 12,000, right? 4 times 12, 48, 50,000. There you go. Okay. So at the most, you're going to be able to pay for mom in the nursing home or the parent, doesn't say mom, the parent in the nursing home for 4 months. Are you kidding me? This is insanity. Also, the adult child has said they intend to transfer the remaining money to an account in their own name with the claim it will only be spent on the parent. Hardy har har. There's a way to do this. It's called a D4A trust, or call it a Medicaid payback trust. You could also put the proceeds, all of the proceeds, into what's called a pooled fund. This is basically it's a charity payback trust. The key is that if you sell the house and now you have assets in the name of the Medicaid person, if they're young enough, and mom, it doesn't say how old mom is, I'm just going to get what the parent is. I'm just going to guess that they're too old, because they probably are, to do one of these payback trusts. Now, it still works. The pooled fund still works, but just a total mistake. In their own name with the claim that only be spent on the parent. Well, this makes all of the money a divestment, all of it. So you sell the house, you get $100,000, you put it in an account in the child's name. Now mom's off Medicaid for 10 months, but it gets worse because the 10-month penalty period, that's what they call penalty period. The 10-month penalty period doesn't even begin until the money's all gone. When the money's all gone, right, and mom is now otherwise eligible for Medicaid, that's when the penalty period begins. Well, we already know that you only got about maybe at the most 4 months, but the penalty period doesn't, if mom's name's on the account, the penalty period doesn't even begin until, until the money's all gone. So it's 10 months after. What happens then? What happens then is mom gets sued because the nursing home likes to get paid, because it's expensive to hire all those people who work at the nursing home. Somebody's got to pay them. If Medicaid's not gonna, it's got to be mom or the parent. Keep saying that, mom. Anyway, it's got to be the parent. And if the parent doesn't pay, the parent gets sued. And then they start looking for, well, why isn't Medicaid paying anymore? Oh, because we sold the house. Okay, well, what happened to the proceeds to the sale of the house? Oh, that went to this kid over there who mismanaged the account so badly that now mom's not eligible for Medicaid anymore. Oh, and by the way, they also reimbursed themselves for $50,000. Okay, now start counting up the criminal offenses here, right? You've got financial abuse of the elderly. You've got, I don't know, embezzlement, probably, conversion of funds, certainly. You get all kinds of problems. And most of it is going to be visited on the kid who's doing these stupid things. And mom's not going to get kicked out of the nursing home, because once you're in, you're in. Okay. So who suffers? The nursing home suffers because now they can't pay the people who are caring for mom. Mom suffers because, to the extent that she recognizes what's going on, but her reputation certainly does, because now she's getting sued. Mom hasn't been sued in 100 years. She's 100 years old. Parent hasn't been sued ever in their life. And now they're in a court case when they're in a nursing home. Are you kidding me? And at the end of the day, it's stupid, because this adult child who's cared for mom gets nothing other than, a felony conviction for taking mom's money, embarrasses the family. I mean, there's nothing good about it. There's nothing good about any of this, right? It's kind of interesting. The person writing this says, "I truly do not give a flying F with a certain number of asterisks after it what my sibling does, but as a matter of familial obligation, I do not want my parent to be involved in Medicaid fraud or even the appearance of it." Well, it's probably not Medicaid fraud, right? It's probably not fraud, but because you're not lying. You're saying, hey, I sold the house, I got the cash. Great, you're off Medicaid. Oh, I gave the money to myself. Okay, you're still off Medicaid. Now you get a 10-month penalty period. If it's $100,000 or so. Okay, so it's not really Medicaid fraud, and the criminal is not going to be mom. The criminal is going to be the one who's doing all this crazy stuff. Now, here's the thing. If it's done correctly, if it's done properly, in a case like this where we've got, and here, there's just so many aspects of this. It's like we still have the house. Great. So let's use the house. Let's leverage the house to provide extra care for mom. Okay. So let's say I've got a family member who's willing, to pony up some money on a monthly basis to add on to what Medicaid will already pay. I can do a home equity line of credit against the house with the child who's loaning the money as the bank. Do you see? So now, after mom passes, the person who put the money up now can get repaid. And if the child actually spent their time and money on mom, actually deserves reimbursement, right? Well, let's have a family meeting about that and come to some conclusion before the parent passes, right? Before the parent passes, so that the child who sacrificed everything for the parent can get reimbursed. You're listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. Now's the time. Well, a little bit past time to give us a call at 774-2424. Although we got John who did. Good for John. But it's not too late to go to the website, davidcarrierlaw.com. Sign up for one of our free life plan workshops. I also want to warn you that if you have been on Medicaid, been receiving Medicaid benefits, the redeterminations have restarted after about a 3-year hiatus. And it's as predicted. I mean, you're just seeing a lot of non-compliance, and we'll just have to work that through. Also, starting in July, so in just a few weeks, there'll be the COVID rules are coming off the PACE program, and so we're going to have to comply with the usual rules. We've been warning you about this for years, and it's finally happened starting in just a few weeks. We got the word a couple of weeks ago. If we've already gotten you qualified for PACE, if we've gotten on the application, don't worry. Everything's been grandfathered in. There's no problem. But this is musical chairs, and the music has stopped. Unfortunately, that's for PACE. So just a couple of updates. If you're already receiving benefits. Hey, John, how can we help this morning?
Well, my mother-in-law died,
Okay.
and we had put her in a nursing home.
Yeah.
And my wife had become the guardian and conservator for her.
Okay.
And she didn't have a will, but she did say that she wanted her money, whatever she had left over, dispersed to her and her sister. Okay, here's the problem. There sits the money, and we have to finish this off with probate court, that do the final paperwork and all that. But
right, yeah.
When they asked her, where's the money? She says, well, it's in an account with, me and my mom. And they looked at her like, whoa, really? It's supposed to be in an account in her name with Janet as something. Well, it's always been in an account with my daughter and her mother, and there sits all this money. I think they told her, well, you need to disperse this money right now. And kind of quietly. Do we have to go to probate on this? That's all she has left is about $15,000 that we're using to pay for her nursing home.
Yeah, no. No, I understand. No, it's a joint account with your wife, your daughter, and your mother-in-law. Is that right?
I'm sorry?
It's a joint account with your wife, your daughter, and your mother-in-law. Right?
No, it's just my wife and her mother.
Oh, all right. Well, it's a joint account, right? Did I get that right?
Correct.
Okay.
Yes.
The fact that your wife was the conservator for her mother and paid her nursing home bills, right? That happened. And she disclosed all these assets. Was she conservator or just a guardian?
She was both.
Okay. So, but she's accounted for all these assets. The fact that you've got
Well, it was her mother's assets, yes.
Yeah, that's what I mean. That your wife accounted for her mother's assets in the conservator.
Absolutely.
Yeah, and the conservatorship and all the rest. Okay. And then it's a pay on death situation. Mother-in-law has died and your wife just gets the money. There's no probate on that. Now you do have to you have to give a final accounting in the conservatorship.
Yes, that's being done now.
Okay. Well, you did a final report of guardian, right? Let me just file a death certificate on that.
Yeah. Yep. They haven't had the Zoom meeting with the judge yet, but all that paperwork's been delivered to the court.
Yeah, it's probably going to be a referee, or might be the judge, or might be the probate register or somebody. Just depends. Right. But no, I don't think there's any. You don't have to go through. You don't have to go through probate on that. It'd be the small estate affidavit anyway. Have we paid we paid the funeral and all that's taken care of, right?
Right.
Yeah. So, no, it's a joint account, so it goes to the survivor. And
they were very surprised though when my wife said it's a joint account. They go, what? Because apparently, when you're a conservator, she has her mother had to have an account with Janet as something, but not a joint account.
Right.
And they were a little surprised.
Yeah. That's the deal when you're a conservator, is you've got to have a separate account that's got only their name on it, and you have control over it as the conservator. So it is a little bit a little bit unusual, but it's not much money. It's what, $15,000, $15,000, something like that.
Yeah, that's yeah.
Yeah, so you
just wondering how much time my wife's going to do.
No. How long was she conservator?
Okay.
How long was she conservator?
I'm sorry?
How long did the conservatorship go on? Yeah.
She's been conservator for 5 years.
And so she's been filing annual reports and right along the accounts.
Yeah. Oh, yeah. Yep.
Yeah. Well, it is it is unusual. I mean, you would expect there to be a conservatorship account, and then the assets would pass through the after death. Then you do a small estate on that one. But
well, what is that? What is that she has to file for small estate? Does she have to file that? They told her just to disperse the money and do it now.
Now, who's the they? Are we talking about the people at the probate court?
They was probate court said, one woman said, you need to disperse those within so many days. And I think she was saying disperse it before we meet.
Right. So give them a fait accompli. The thing is, if mother-in-law's name was the only one on the account, then you would do what? No, I'm just saying if she was, right? And this year, if the estate is valued at less than $27,000, then it's the small estate. You just do an affidavit, right? So you don't go through the will, and you don't do a formal probate and inventory and all the rest. As it is, I think what they're saying is correct. Just withdraw the funds from the account and show a zero. You explain it. You got to put it on the. You're not trying to pull the wool over the eyes of the probate court. That is disaster. You never want to do that, right? But you just say, look, it was a joint account, and you've seen my accountings. They've been approved every year. There was this much left, and here's where it went. Done. And then the likelihood is that the referee is going to say, well, it really should have been a separate account or something like this. But no,
nobody told her that.
Yeah. And there's a no harm, no foul aspect to it. You know what I mean? If
right.
All the bills have been paid, there's nobody going to complain about what she's doing, then it's just one more way to get to the same destination. It's not the way you'd want to do it. In the probate court, depending on which court you're in, can get persnickety about it, but I think you'll be fine. You've been listening to the David Carrier Show. Okay. All right. Thank you, John. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney.